To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
And that was Judge Beverly Cannoni declaring a mistrial in Karen Reed's first trial that was held last July. During that case, Adam Lawley was the lead prosecutor, and he presented testimony from a total of 68 witnesses. And this time around, new prosecutor, Special Prosecutor Hank Brennan, has taken the lead and cut the number of witnesses almost in half, with jurors hearing from only 38 witnesses. Now that the Commonwealth has rested their case, let's take a look together back at some of the highlights from the prosecution's case.
You will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, you will learn that Mr. O'Keefe got out of the car and he stood by the side of the road after an argument with the defendant. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull, and she simply drove away.
Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty.
Did you receive a phone call?
Yes, from Carrie Roberts. She said John was found in a snowbank. They don't know what happened.
And at some point, you ran over to where Miss Reed was?
Yes. EMTs were around, and they were working on the body. She was running around and saying, did I hit him? Did I hit him? Is he dead? Is he dead?
There was a woman next to us who told her to calm down, stop talking, calm down, you're hysterical. So she repeated, I hit him, and a police officer asked her, said, you what? And she repeated it again, I hit him.
At some point, were you with the defendant when she spoke to an officer and a first responder?
Yes. She told the first responder, I hit him, I hit him, I hit him.
Was it important to you, before you testified, to tell these jurors, under oath, that my client said, I hit him 3 times?
As a juror, as a witness, it's important to tell the truth and to answer the question you were asked.
And in point of fact, in your entire grand jury testimony, you never said, my client said the words, I hit him, did you?
Again, it's 227 pages.
Ms. McCabe, you were there. They're your words. I'm not asking you to rehearse something. You were there. Did you tell the grand jurors that my client said I hit him?
I have testified a number of times, but I was there the morning of January 29th when your client said, I hit him, I hit him, I hit him.
The defendant stated that she dropped Mr. O'Keefe off at 34 Fairview. She did not see him go in the house. She was asked about the damage to her rear taillight, to which she stated, quote, I don't know how I did it last night. She stated that she made a 3-point turn and left.
When you came out of Meadows, did you have a chance to look at the defendant's taillight on her Lexus?
Yes. Karen pointed out and said, look, my taillight. And she said, do you think I hit him?
Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
That night, do you recall if there was any other pieces of taillight recovered?
I believe in total we located maybe 6 or 7 pieces of taillight.
What type of work were you assigned to do in this case?
So I was given items of plastic for comparison. The red plastic that I sampled from the debris from the clothing was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight.
He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
His body was completely covered, but his head was completely covered, so I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it.
There were a series of cuts and bruises to the right arm. There was also a bruise on that same arm on the back of the hand.
Did you come to a conclusion about the manner and cause of Mr. O'Keefe's death?
The cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
What was the total snow accumulation from the storm in its entirety?
23.8 inches.
Okay, so just short of 2 feet, is that correct?
That's correct. The ground was frozen, the soil was frozen, and the surface of the ground was frozen. And it would have made the ground impenetrable.
Why did you go back to the spot where John was lying when you first saw him?
When they lifted him up, there was grass underneath him, and I could see his phone.
At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. The message, "Pull behind me," is red. 32 minutes and 9 seconds, the message's application is closed. And the device is locked for the last time.
At 12:53, that's about, what, 21 minutes or so after that phone stops moving? What's the temperature?
61 Fahrenheit.
You mentioned that you were looking for time information or power on information regarding 2 events.
Correct.
Can we characterize those events as tech stream events?
Yes, we can. That second tech stream event is a backing up maneuver.
When you looked at the time from the Lexus clock regarding that backing event, did you do an analysis of John O'Keefe's phone?
Yes, I did.
When you apply that variance between the Lexus clock and Mr. O'Keefe's phone,
The time of that event with the clock variance adjusted is between 12:32:04 and 12:32:12.
You would agree that there's not even a degree called Bachelor of General Science in Mathematics and Business Administration offered at the University of Alabama, correct?
Correct. That should be Bachelor of General Studies with minor in Mathematics and Business Administration.
And what you just articulated, you do not possess as you sit here today, correct?
That is correct.
just a few days before this incident, you were aware that Mr. O'Keefe asked her to leave, but she wouldn't.
At 12:37:08 a.m., the defendant calls John, and voicemail number 1 is left. 12:59:24 a.m., the defendant calls John, voicemail number 3 is left.
John, I'm here with your kids. Nobody knows what the was pervert.
Do you know if there was any jealousy in that relationship?
Karen wouldn't let, I mean, they did everything together, a lot of things together, and I thought at times, yeah, you could see, you know, she didn't want other women around John.
The niece of the victim, Officer John O'Keefe, she took the stand today. She was soft-spoken as she talked about the breakdown in the relationship. Then they went into details about the possible motive in that Aruba trip. She said that there was a lot more tension and fighting. And then she went on to describe the fact that her uncle, who again she called JJ, asked Karen Reed to leave his home after that trip, that New Year's trip, and Karen Reed refused to.
The totality of, you know, to put a label on the whole thing, my opinion is that she's trying to get revenge.
Get revenge
Yes, get revenge.
On John?
Yeah.
For what happened on New Year's Eve?
Yes.
Let's bring back in trial attorneys Michelle Thomas and Madeline Somerville. And I want to start, ladies, with Hank Brennan. Not only did he really cut the number of witnesses almost in half, but his different approach, his different strategy. He started with testimony of, I hit him, I hit him, I hit him, that a first responder said that's what Karen Reed said at the scene. Also, how he's incorporated clips of Karen Reed, in her own words, doing many interviews, and just little pieces of that throughout the trial. Madeline, you first. Effective or not?
So I'd love to address the I hit him quote. I think that jurors are going to give her the benefit of the doubt on this one because this was her husband. This was a shock and horror moment. And people often will say things that they don't mean and admit to things that they don't quite understand yet. So I think here, when they keep bringing this up, it's going to force the jurors to start pushing away more information that that other side is giving them, right? They're like, you're pushing this a little bit too hard. We understand that people say crazy things in that moment, and that actually in that moment, if she was assuming responsibility, that actually makes us trust her even more. So I think pushing that quote could really backfire.
And Michelle, what do you think about the fact there were also witness testimony that the quote was, did I hit him? Could I have hit him?
Yeah, so I take a different approach on that. I think it was extremely effective to open the state's case with her own words saying, I hit him, I hit him, I hit him. And even if the corroborating testimony that came after raised questions as to whether she said I hit him or did I hit him, the reality is that is not most people's first thought. If you're dropping a loved one off at a party and then you find out later on that night or in the morning that the person is dead, my first thought isn't, oh my goodness, maybe I killed him or maybe I hit him. You're panicked, you're concerned. And so when you add that to that, the voicemails, the raging voicemails she left for him, the text messages that were quite aggressive about their relationship, and the anger, which could add motive to why she may have just backed into him, maybe not intentionally, which goes to the second-degree murder charge, but maybe not intentionally. But that's just not, I think, most people's first thought. So I do think it was compelling to open with her own words and alleged possible admissions and end with her own words.
Now, I will say this. I think if we add into there the drinking, because we know she had been drinking the night before, perhaps is that why? Did I hit him? Could I have hit him? I was drinking. I don't remember my driving very well. Nobody has said that. I just have to wonder if that could be part of it. But let's move on and talk about Michael Proctor, because talk about damaged goods in terms of all of the baggage he brought to the stand the first time around, because we know really an embarrassment to law enforcement investigations at the end of the day, and had consequences because of his lack of ethics in his investigation that he conducted in this case. He didn't testify, Madeline. He didn't testify in this case. We don't know whether or not the defense is going to call him. I think the defense should call him and put that baggage on the stand. But your thoughts?
I absolutely agree. I think that if they call him, then that adds a lot of credibility to their case because it shows how much they believe in it. And here's the thing, trying to prove a conspiracy is really tough stuff. And I actually agree with my colleague who just said that I don't think that's most people's first thought when they find out that their husband has died, right? Did I hit him? Or that might be a reasonable explanation, that might be their first thought. I agree with you. I think it's because we've complicated things so much. When that happens, jurors tend to give people the benefit of the doubt in places where they wouldn't normally. And I think that also is going to happen here with Proctor, because if there really is this conspiracy going on, it's very difficult to believe. So how far are the jurors willing to let their benefit of the doubt go, right? How far are they willing to go before they say, you know what, that's just too far for me to believe, and that's where reasonable doubt gets cut off.
Yeah, that's fair. Let's listen together, Michelle. I want to remind viewers, or if any are just viewing us, just a little bit from Michael Proctor in his own words during the trial the first time around and what he said.
So these came from me. From all accounts, he didn't do anything wrong. She's a whack job.
Objection.
So don't spell it. You have to. So these are your words, Trooper Proctor?
Yes, Your Honor.
Go ahead and say them.
Yes, she's a babe.
Weird Fall River accent, though. No ass.
All right, Michelle, your thoughts about Michael Proctor?
Look, Proctor is a problem for the prosecution, and he has been in both the first trial and the second one. Now, the state attempted to deal with his problematic text messages through alternate witnesses without centering Michael Proctor. But I do think that if the defense brings Proctor in and has him reads his own words, the name calling, the disrespect, the unprofessional behavior by Proctor during this investigation, that it will be more impactful than the way that his comments came out during the state's case in chief. So I would vote yes in terms of calling Proctor during the defense's case.
And I'm not saying that to say she's innocent. They better present that. That's not what Court TV is attempting to do. What we're attempting to do is to talk about strategically all of the evidence that's been presented by the Commonwealth, as well as the defense doesn't have to put up any evidence. Are they going to? Should they? That's what we're talking about here. Ladies, stand by. Coming up next, we'll take a look at Karen Reed's courtroom reactions and animated gestures during testimony. How does that affect a jury? Stay tuned. We'll be right back.